Hi, I'm Emma Douthwaite, Safeguarding and Welfare Manager at the Office for Students. From the 1st of August, our new condition of registration means that registered universities and colleges in England must take certain actions to protect students from harassment and sexual misconduct. In this video, I'll answer common questions from universities and colleges about how they should comply with our regulation in their partnerships with other higher education providers. For example, where a provider delivers a course or validates qualifications on behalf of another provider through a subcontractual relationship, or where they deliver transnational education to students. The new requirements apply to all higher education students at universities and colleges registered with the OFS. This means that all courses at all levels, whether they are research programs, apprenticeships, or short courses, delivered face-to-face, remotely, or both. The requirements cover all the students who are registered with you, taught by you, or studying for an award provided by you. This includes international partnerships and subcontractual arrangements, UK-based and non-UK-based students, and courses delivered through partnership arrangements both within the UK and internationally. This might mean more than one provider is responsible for protecting some groups of students, so we would expect lead providers and their partners to work together. Firstly, I'll look at transnational education, or TNE. Condition E6 contains several key definitions, including those on harassment and sexual misconduct. We understand that countries where transnational education is delivered may have different cultural contexts and laws around harassment and sexual misconduct. Where we draw from definitions from UK law, such as the Equality Act or the Protection from Harassment Act, we are not suggesting an extension of the scope of that legislation itself. Rather, we expect that your policies and activities should reflect these definitions as they support clarity and consistency. The country in which your institution operates may have its own requirements. You should check whether you need to update your policy or use additional wording to meet overseas requirements. The condition has been drafted in such a way to give providers flexibility in how the requirements are met, and you may consider taking different approaches in different contexts. You may find it useful to engage with institutions delivering higher education in the same countries or regions to inform and support robust approaches. It's worth noting that the Higher Education Freedom of Speech Act does not apply in TNE contexts. Moving on to partnerships, including validation and franchising arrangements. We know that local policies and support systems can have significant benefits for students. We strongly encourage lead and delivery partners to collaborate where appropriate and beneficial. For example, there may be benefits from a subcontracted partner designing and delivering training and support for students, which is overseen by the lead university or college. Alternatively, there may be benefits in the training, reporting, and support systems being replicated by those delivered by the lead provider. Collaborative working on investigation processes could help you to meet our requirements that these processes are free from any reasonable perception of bias. And joint efforts on prevention may also prove to be more effective and resource efficient. Our condition is designed to allow for a variety of approaches. Our focus is on our requirements being met, and we would encourage you to collaborate with your partners to develop and deliver approaches that are effective in your context and for your students. In addition to franchise and other partnership arrangements, you may also have relationships with other organisations which provide a fundamental part of a student's academic experience. For example, businesses which provide a year in industry, NHS trusts which provide placements for medical courses, and international partners for a year or semester studying abroad. We recognise that these organisations are likely to have their own policies related to harassment and sexual misconduct, and that you may have less influence over harassment and sexual misconduct conducted by individuals who are not students or staff of your university or college. However, you should consider what sort of action is appropriate for addressing harassment and sexual misconduct in these contexts. You are required to take significant and credible steps to protect students from harassment and sexual misconduct. You should consider how risks might arise from work and study placements. For example, seeking assurance that partners delivering these have appropriate arrangements and policies in place to identify and respond to risks. If you're made aware of issues of harassment and sexual misconduct for students on placement, you should take prompt and effective action to ensure that students are adequately protected and receive appropriate support. This could include engaging the organisation to ensure action was being taken to investigate alleged incidents or prevent future ones, or ending the placement relationship where appropriate assurances are not given. Thank you for taking the time to watch this video. We hope you have found it useful to understand our requirements in relation to partnership provision and transnational education. We have more information on our website, including the full condition and detailed guidance, guides and webinars for students and higher education providers, as well as our guidance related to freedom of speech.